typing is an essential after dictation. Try exam-oriented typing tests, check accuracy, number of errors, gain speed, and more. Complete the typing test in a given time. Read dictation materials. Subscribe to get contents via mail. Purchase shorthand journals and more.
The appellant's defendants are in regular second appeal against the concurrent findings of the Civil Court at Kaithal dated 14th October 2019, whereby the suit of the plaintiff respondent was dismissed and against the decision of the lower appellate court dated 19th February 2020, by which the appeal was also dismissed. Counsel for the appellants has vehemently submitted that the courts below were in error in declaring the suit as the jurisdiction of the civil court was barred, and the proceedings under section 135 of 80, the Electricity Act 2003, for short, the Act had been initiated against the respondent consumer. On a perusal of the record, this court is of the opinion that no substantial question of law arises for consideration in the present regular second appeal. The facts would go on to show that for checking done, the notice had been issued as electricity assessment charges for rupees 8,000 as compounding fees on the compounding of the alleged theft. Same were challenged by the plaintiff on the ground that no opportunity of hearing was given to him and the meter was installed outside the premises of the plaintiff, and he had already installed solar energy equipment in his premises and he was using solar energy. The defense of the present appellants was that on checking, it was found that the load shown was running through the meter and load shown was connected directly by passing the meter, and thus the total connected load against the sanctioned load of 500 kilowatt. The plaintiff had refused to put his signatures upon the checking report, and resultantly both demands were issued and later had also been written to the SHO Jind for loading the FIR against the plaintiff for using the electricity dishonestly by committing direct theft. On the framing of the issues, the trial court very secondly examined the provisions of the Act to came to the conclusion that Section 126 on one hand and the provisions of Section 135 are distinct and different and operate in different fields and have no common premise in law. Reliance was rightly placed upon the judgment of the apex court in the executive engineer and another. The relevant portions of the judgment read as under. Upon their plain reading, the marked differences in the contents of sections 126 of the 2003 Act are obvious. They are distinct and different provisions which operate in different fields and have no common premise in law. Full stop.